Well, good morning or good afternoon, depending on where you are. Welcome to a book launch live cast here with Ignite Press. Today, I've got a special guest, Eric Matlin, and I'm going to bring him on just a minute to talk about his book and your life, because these two things happen to be connected at this point in time. So first, I want to share with you that here at Ignite Press, we specialize in helping bringing nonfiction works to the world that will be used to improve your business, your brand, your organization. And so if you have considered writing a book and using a book to help build your business brand or organization, reach out to us. We can be found at ignitepress.us, ignitepress.us. All right, so this is the book we're going to be talking about today, The Procrastinator's Guide to Wills and Estate Planning. This is the fourth edition of Eric's book. He has put a lot of love, sweat, and more importantly, wisdom into this book. And in fact, today you can pick it up on Amazon. We're running a launch special where you can get the Kindle version for 98.9 cents. Now, Eric's the founding partner of Matlin Law Group in Northbrook, Illinois. He's been doing this for more than 30 years, concentrating his practice on estate planning and helping thousands of families achieve their planning goals. Let's bring Eric on. Eric, how are you doing today?
Oh, just great. I'm living it every day at a time and loving it.
This is a big deal. Today's your book launch. And it's funny because you've had this book out for a while, but this is the fourth edition, a brand new revised edition that we've worked on. And its first real launch, because you've been using it in your practice all this time, right?
Yeah, I've never really done anything to market my two books. Also not dead yet, so Plan Your Estate, but is coming next. But it's always been about educating people and being transparent in my practice. And I just have a very good karma practice. Matlin Law Group is the name of the practice in Northbrook. And I never worked for another attorney. I had mentors along the way, but I've always been very tuned into educating people and being as transparent as I can with fees. And my book just is a furtherance of that goal, is to educate people about why they need it. Why they shouldn't wait anymore, because I'll run into people and they'll say, "Oh, I know I got to get with you, but that's just not the time yet." Especially if they see me at a funeral or something. That happens too. So
yeah, that's a little later than we'd like to see. Eric, I just want to let people know that if they're watching this, they can certainly add their comments to the chat. If they have any questions that people would like for me to pass on, I'd be happy to do that. So please, everybody, if you're watching, just go ahead and say hi in the chat, and we'll incorporate your comments actually into our conversation. So, Eric, first, let's just go to, well, first you've got a practice there in Illinois. You've been helping people for 30 years. What's the first, what made you first sit down and write The Procrastinator's Guide? What made you go, okay, we need a book on this?
Well, it's famously, this topic is something that people don't want to address. And they feel, many cases, that they're not ready for it. They need to be older. But the one thing we share is that after being born is that we all die at some point. And you don't have to be obsessed with death to want to take care of the business aspects, all the loose ends, or as much as you can while you're still competent, because you're probably never going to be more competent than you are right now. And so, now is as good a time as any to get things done.
Yeah, and in fact, I was going to say that funny story. We were getting ready to go out of the country a couple months ago, and of course, usually when you're going to do some long travel, that's when you start thinking about, what ifs, right? The what if the plane crashes? What if I get sick while I'm abroad, or whatever? So I scrounged out our wills and found out that we had not updated our wills since just before our first child was born. He's 25. Um, and so that was really bad. I'm not alone in admitting this, but we realized that, and actually, no, our children were born, now that I think of it, but they were like 3 or 4. And so the will was more about who was going to take care of the children and that type of thing than anything else. So, yeah, we've procrastinated quite long enough. So it's time to make some adjustments there.
I do get calls from the airport. Hey, I'm about to get on a plane. Is everything okay? And it's a little late to ask that question, but if you do wait too long, then it is too late to do these. You need to have capacity in order to do estate planning. It's not a real high bar of capacity. So even if you've got
It looks like we might have lost you for just a second. Hopefully you'll be back. Um, so let's do, oh, here you are. You're
here I
back.
am. Yeah.
Yeah. So you're saying it doesn't take a lot of capacity to be able to execute a will?
Right. It's wills, it's powers of attorney, it's trust. And as long as a client can articulate what they want to do without coaching in most cases, then they can do these types of documents. And really, it covers just about everybody from the age of 18, a child of yours, the status subtly changes to becoming an adult. That child may look the same, but their status is different. And with things like HIPAA laws protecting privacy, let's say you send a child off to college and they bang their head and can't give consent for you to look at their records or even to talk with the medical staff, then you find yourself in a world of hurt. So as a firm, and this is just an aside, is that any clients that have kids that are 18 to 26 will give them powers of attorney for healthcare and a standalone HIPAA authorization, just so that the parents can continue to be parents, and they had, though they've lost that status of automatically being able to look at the kids' records.
Eric, I've never heard anyone talk about this. About, yes, we send our kids off to college and then we discover that we have no rights to learn their grades or anything, even though we're paying for the education. But it had actually never occurred to me about the HIPAA rules as they apply to their health. So that's a great idea, is to have some sort of legal document that allows us to help each other.
Yeah, it's like
Right.
that's estate planning 101. So
Yeah.
then from there, let's say it's the parent that has very few assets, a married couple, let's say, but they have term insurance of $1 million or 2 million, and they name the spouse as the first beneficiary, but who's the secondary beneficiary? If God forbid something happened to you and a spouse, or even just to you if you're not married, would you really want a child to inherit that sum of money at age 18, no strings attached? If you wouldn't want that, that's why you may need a trust, so that somebody can control the assets until the child reaches an age at which they can take over the management of the money for themselves. But up until that time, the money's there for their benefit. So.
Yeah, I think those are really salient points. We've got some questions from the audience that I can share to you, but I have questions first. So, but I will get them. So thank you, Chris and Kathy. I see your questions. We'll bring them up in just a moment. Eric, you guys, you're based in Illinois. Um, can you help people in other states?
Matlin Law Group practices in Illinois. I only practice in Illinois because this is where my license is only. But one of my partners is licensed in Wisconsin, so we'll do work in Wisconsin. And another one just passed the bar in Florida, who's had been practicing over 20 years in Illinois. So we're gonna branch out to there. But law is a little different than other types of, if you think of estates and wills and everything as financial services, they're legal documents, and it's difficult to plan across state lines. But we'll help a client find somebody in another state because they're heartbroken. They're happy about moving to Florida. Maybe the taxes are a little better than in Illinois, or they just want the year-round heat. But we will fix them up with very good lawyers. That's one thing about estate planning is you look for certain credentials if you're hiring somebody, and we can help filter all those attorneys out there that really you want somebody that's not a specialty so much as they concentrate their practice on this.
Okay. So I'm going to pass on here a couple of questions. First, a fun one. Chris asks, what's the strangest place that you've heard of someone keeping their estate plan documents?
Well, the worst place could be, and this is not always the case, but the worst place can sometimes be a safe deposit box, because if they're going to cut off access to that box and there's not an authorized signer upon incapacity or death, that's a problem sometimes. I know that people keep them in their freezer, and people are always bring up the examples. Well, what if the house burns down? Let's say I just keep them in my own house. I keep them in a file cabinet. If the house burns down, well, I had one client where the house burned down. They lost the documents, but they were here. They didn't die in a house fire. You don't always need the originals. We keep a electronic version of every document that we've ever done in 30 years. So it'd be unusual for the family not to be able to access the documents. But generally, file cabinet, that's not too funny of a place, but that works usually.
Do you recommend that people give copies to trusted loved ones?
If there's no controversy, if there's controversy, then why start an argument within the family before you need to? So there's really no set way of doing it. It depends. When I sit down with a client, where anybody at Matlin Law Group sits down with an initial client, like we're just beginning our relationship, we're not even, we spend more than half the meeting talking about family dynamics, because that's what we're dealing with here. We want to know, obviously the client's contact information and all that. We also want to know who are the players in the family. What are their relationships? We want to know who the prodigal son might be, if there is one, or the outliers. We want to know the spouses. We just want to know a general picture of how the family, what the relationships are, and who would you select as the person that could make medical decisions. Very personal things like that. But there's really no set rule on that. If one child feels that they should be over another child, they should be selected next on a power of attorney, and it's going to cause a problem, then we just don't share it.
Right.
But usually some of the agents under the financial power, under the healthcare, we usually want to give that to the doctors and to the agents and the people that will be acting as fiduciaries in the future.
So you just brought to mind, I'm sure, many movies, but did you enjoy Knives Out? Did you see the movie Knives Out?
Yeah, it was okay. If I'm going to the legal estate planning movies, I tend to go towards. There was Body Heat with
All right.
William Hurt and Kathleen Turner, where there was a very arcane piece of the law that any of the attorneys out there listening knows is something that you spend half a semester of law school on and nobody really understands it, which is the rule against perpetuities. And the rule against perpetuities is a very short statement, and it backs to William the Conqueror, I think 1066, and it's that no trust may be created to last longer than 21 years and a life in being, which that short statement has been subject to so many controversies over the years, and now most states just waive the rule against perpetuities. The other movie being The Descendants with George Clooney. That was also about the rule against perpetuities, where he had to do something with this massive tract of land in Hawaii. But
Wow.
those are arcane things, but they amuse us.
I love it. I love it. It's funny. I forgot Body Heat, and gosh darn it, there's another movie I'm thinking of right now, but it'll come back to me later. So a couple other questions here. Kathy asked a great one. She says, "I have a will, but I keep hearing about a trust. Why would I need that?"
Okay. Um, a lot of people use revocable living trusts in their planning. And the reason is, you might see the words avoid probate. So avoiding probate just means staying out of court. So that's one of my primary jobs when I'm meeting with clients. Let's do what we can via powers of attorney and trust to stay out of court. And you can stay out of court. You can turn an asset, a financial asset, can be a non-probate asset simply by naming beneficiaries. But sometimes beneficiaries, by naming them, you're not providing for contingency planning. I mean, what happens when somebody dies out of order, for instance? Out of order being, in my mind, and not in the expected way or too young. Okay. A trust will, besides potentially staying out of probate, and that's what the revocable trust is all about, there's trust provisions within the trust that control your money. I mean, if you've spent your life, if not controlling your children, let's say it's at least influencing them a lot, they may not be ready for money, or a grandchild, if God forbid a child should predecease you, okay, is you want to exercise some control. And that's really where the trust shines, because that early example I gave of the $1 million insurance policy, if somehow it lands in the lap of not necessarily an underage person, but it could happen there, but even a young adult that has not shown a readiness to be able to handle large amounts of money, then the trust is the only way to do that. And you can make it as flexible or as tight as you want. Again, it always depends on the family dynamics. And that's what a trust will do, that nothing else will do, is it will control the assets to the extent that you want to control them. And, in my trusts, or I should say Matlin Law Group Trust, we don't use the word withdraw to a client for their children eventually. Instead, what we'll generally do is we may incrementally allow the children to become their own trustees, either over some period of time or at certain ages.
Right.
And so they can be a little bit more ready to get the money. I mean, would you rather, some people say, well, I don't want a trust fund baby. But I would ask that person that says that, would you rather have a blew my inheritance loser child? And I think the answer to that is no.
Yeah, I was just chuckling here. George Butler put a comment in. He said, "I'll get this book tomorrow." I think playing off the title, "The Procrastinator's Guide." The funny thing is I didn't realize it was a joke until Chris called it out, and so I'm grateful. I'm not always the smartest guy around. So You bring up a good point, because there are, you think about it, in each family dynamic, they're all different. In some families, you've got an 18-year-old that could be entrusted with lots of money, and in other families, you've got a 40-year-old who couldn't, right? And so I could see where that dynamic would be different, and you would want to create your trust mindful of those things. Why is it called a living trust? I'm just curious.
Well, a living means you create it during your lifetime. So, without being too technical, a living trust is not exactly the same as a revocable trust. The revocable trust means you can use it any way you want during your lifetime. The living part is that you create it during your lifetime. The revocable just means, it's not even generally, there's some exceptions, but it's generally not even a tax entity. You can have, it's kind of like your financial alter ego. The revocable trust, you're the trustee, you're the grantor, the person who puts money in there, you're the beneficiary, the person that gets its benefits, and you're also the trustee, the person who controls it. So you're wearing all of those hats. And then you're saying, and upon my death, this is who it goes to. And the reason that there's no probate is not because you have a trust. It's just because assets that are owned by trust don't have to go through probate, because the trust doesn't die. If you become, while you're controlling these, while you're well incompetent, it's fine. You become incapacitated, then whoever is acting as the trustee, whoever I would name that comes next, should continue to use the money that's in the trust for my best interests. And then upon my death, again, the trust doesn't die. It just says upon my death, then this is the new trustee. These are the new beneficiaries under any formula that I can comprehend and articulate to my lawyer. You could put anything in there, and as long as it's within, the lawyer will tell you if you could put it in there, as long as it doesn't contravene public policy. But you can lock up money pretty tight to make sure that it doesn't end up going to your child's future ex or something like that, especially when you already know that there's problems on the horizon. You may not always want to give money outright to people. And lastly on that is that the revocable trust is not a tax entity during your lifetime. It just uses your social security number as a tax ID number. So all the income gains and losses just flows through to your regular return. It doesn't make life more complicated. And just because you're doing this doesn't mean you're obsessing about it either.
Okay, so this is really good, because one of the thoughts, and you can tell I don't have a trust, is that, okay, to do a trust, I've got to move a bunch of assets around. I need to create like a business entity, like a corporation, like when I created my S corp, and I've got to have all these crazy rules and minutes and all of that. You're saying that's doesn't have to be all that way?
Yeah, it's there's really no complications during your lifetime except for structuring the trust. Your attorney should be able to guide you through ownership designations and beneficiary designations, so that the trust might be the first beneficiary. For retirement plans, it might be the secondary beneficiary after a spouse. For a big account that somebody owns, brokerage, stocks, bonds, whatever, you are the trustee, and so you'll get a statement that says the trust of Everett O'Keefe instead of just Everett O'Keefe as an individual. And by just retitling your assets, it's something that you go through once, and then hopefully you don't have to do that again for the rest of your life. You may amend the trust and change it as circumstances changes. You've got your, let's say, children that you first did the trust for when they're 5 years old and now they're 30. Well, you can change it and make them the trustee and the person that steps in instead of your sibling, let's say. And once you structure the estate in the name of the trust or as the beneficiary of an asset, then you would tweak the trust itself over time, because it's not something that you want to hang on your wall and put away. It's something that you can just, it evolves. You don't want to, again, you don't want to be obsessed with it, but you can make changes during your lifetime. And that's what it's all about. It's just a titling change. It's almost like a transparent alter ego, your revocable living trust.
Well, let me remind everybody that the Procrastinator's Guide to Wills and Estate Planning is available on Amazon right now. You can pick up the Kindle version for the special launch pricing of 99 cents, and certainly recommend that you do that. The paperback is also available. And I've got to tell you, this book is beautiful. I think that everyone's done a beautiful job on this. Chris wanted to know what's been updated from third edition to fourth edition. Like, did you find that you had to tweak some things because of some law changes, or what brought you there?
Well, I first published it with it was Penguin Group originally, and I got the rights back. That was in 2004. And it sat there while I wrote this other book, Not Dead Yet, So Plan Your Estate. And then basically, I think in 2020, and then in 2021, I put in new editions. And that was just getting ready for this, because it's been totally redesigned. Was the major change in this edition. It was a larger size. It's got better paper. It feels nicer. It looks nicer. So that's what the fourth edition is all about. And it's got 2022 tax laws, because they haven't been changing too much year by year, the tax laws, but there are certain changes over time that this addresses. And my plan is to keep this book current through future printings.
Yeah, and let me just share with everybody that this is not some tome that's written in legalese that's hard to understand. It's very open and accessible and understandable, and also entertaining, which will help prepare you for Eric's next book, Not Dead Yet, which actually is published before as a graphic novel, which is pretty amazing and unusual. So look for that in the future. So Eric, we have just a few minutes left, and I'd be curious to know, what do you feel like, what's the biggest stumbling blocks people seem to have about getting their act together?
Well, there's, of course, the psychological ones. They don't want to think about dying. They're afraid to look it right in the face, the fact that everybody dies. So you might as well have something, even if you don't update it every year. Let's say you update it every 10 years. That's fine. Just to have something that distributes your assets intelligently, that names the right people to step in, to handle things when you can't. As I mentioned earlier, the healthcare power of attorney is really, I can't understand why anybody goes through life without a current version of that, because think about the last time that death or severe injury might have called you, stepping off a corner with a bus bearing down, or stumbling off a ladder, or just accidents happen. Once in a while people get hit by meteors. You just never know. So there is no right age at which to do your estate plan. But as things change and as estates grow, then they become a little bit more complex. But what I'm doing is not brain surgery or rocket science. I mean, at the very high end, right now there's a threshold for the federal government of $12 million per person that's exempt from estate taxes, which you take a married couple and you double that to 24 million. I hope every viewer of this video has that problem as their major problem. But, as you get up into those types of numbers, 50 million, 100 million, billions, then it gets a little
more complicated.
Yeah, but for your typical person that just is, has nice stuff, that has a moderate estate that they've worked their lives to build up, then you would think that people would care about that. So what's the stumbling block? Maybe it's finding the right attorney, and it's also overcoming any kind of psychological block, because, you may want to just take baby steps. And
Yep, and it looks like we might have frozen a little bit again. And Eric will probably be back with us shortly.
yeah, here I am again.
There you are.
Here I am. So, I mean, there's all kinds of reasons why people don't do it. I had a guy that came in yesterday. He was in the neighborhood, because every time I would see him, he would say something, got to get in there, got to get in there. He called me. He's getting on a plane to Italy on Friday. And I said, well, let's get this thing started at least. I won't be able to have it ready for this trip, but, travel in peace. And that's what people are buying when they do estate planning. They're buying peace of mind.
Well, I assume that on short notice, you can at least, have arrange a will or something like that, right?
He wanted a one-pager. Is there a one-page thing I could do? I was like, yeah, just travel. I said, yeah, you can download a file on the internet of powers of attorney. But, it's that whole thing, being a little bit pregnant or whatever. We're not going to, I don't like to do a little, bridge estate planning. I like to sit down and find, and I did. He and his wife stopped by, and I learned what I need to know so that he can do things intelligently. It's just that last minute thing. Yeah, he could leave a note for certain things, but generally you want to do it the right way.
I want to bring up a couple comments here. I thought this was really great from Missy. Being a mom of 2 young children and having my estate plan documents done really gives me a sense of relief. Yeah, one of the things I can check off my adulting to-do list. The thing I think about there is just the peace that comes with that. We spend so much of our lives raising our children and trying to provide for them with food and clothing and housing and things like that. And yet very often the very last thing on our list is, well, what if we're not around? We don't even I'll get to that. Like you said, we'll procrastinate that. Mark asked a great question. Says, my spouse's trust gives me upon his death, along with a monthly/yearly stipend. Do I pay tax on that?
No, you would only pay tax on any money coming out of retirement plans. And then upon his spouse's death, non-retirement plans get a step up in basis, meaning all the capital gains that accrued during a lifetime disappear. It's a huge tax break for people that are holding on to assets that have grown in value. And, the only taxes he would have to pay are current earnings in a year-to-year basis, and the retirement plans as they come out. But as a spouse, his spouse, he could do what's called a spousal rollover, and he could take a minimal amount each year, and that's how the IRAs are set up. And that's really the only tax, unless the estate exceeds certain limits where there'll be an estate on the tax on the estate.
Okay, and we're going to slip in one more question. This was from Chris. I appreciate you have a chapter on this. I've got a 17-year-old and a 20-year-old. How much should I tell them about my estate plan?
I think they're old enough. Once the 18-year-old. Once the 17-year-old turns 18, then they both need powers of attorney. And certainly if you're selecting them to act as let's say, a healthcare power of attorney, it's a little on the young side. But, unless there's any kind of real controversy in the estate plan, I would, there's no reason not to share it. And controversy being, if somebody's being disinherited or receiving less than a sibling, or let's say one sibling is controlling the other sibling, which can always be dangerous. And that's in many cases not recommended because it can break up relationships. You have to be conscious of that when doing estate planning too. you don't want to exacerbate family problems. You want to heal family problems. So that's how I look at that.
Yeah. I want to remind people the book is available on Amazon, where they can pick it up for 99 cents on the Kindle. Now, by the way, if you don't typically read Kindle, that's fine. You can still buy the book for 99 cents through Amazon.com. And if you're in an app like the Amazon app or the Kindle app, they won't let you buy it because Amazon doesn't want to give 35% to Apple for the privilege. But you can always buy it at Amazon.com. And then there are apps that you can download on any device, on all smartphones, tablets, and even desktop computers and laptops to read the Kindle version of the book. So I highly recommend that. All right. Well, I'll tell you, Eric, we've reached the end of our live cast. Congratulations again on launching the 4th edition of the book. And we're in the midst of an Amazon bestseller campaign, so we're going to have to see what the results are of that. But I just want to congratulate you on doing the hard work of getting this book out to the world, and also just congratulate you on the great things that you continue to do in your practice in helping honestly improve families' lives.
Oh, thank you. I really appreciate it, Everett. I'll just send my love to various friends and family, to Glow and to the kids and grandkids and siblings, cousins, and my wonderful staff here at Matlin Law Group. Again, I grew from one person with mentors, never having worked for another attorney, and now we've got a fabulous practice that really makes me tear up. It's so wonderful. It's such a good kind of a place to be. So this helps that.
Very good. Thank you so much, Eric, for joining us. And everyone else online, thank you for joining us. Again, pick up your copy of The Procrastinator's Guide to Wills and Estate Planning. Now, if you have ever thought about writing a book, or if you've written a book, but you've yet to bring it to the world, and you'd like to talk about what a book could do for your business, your brand, reach out to us. We specialize in helping bring people's books to the world so that they can leverage the authority, the exposure, all the other benefits that come with publishing a book. You can speak with me directly by scheduling a call at ignitepress.us. Just go there and look for the button that says book consultation, and that will get you to my calendar. I'd be happy to talk with you about your book and what one could do for your business and brand. Thank you again for joining us here today on the Ignite Press Book Launch Livecast.